Welcome to You Counsel. The Supreme Court of Canada recently issued its decision in a case called Heller versus Uber Technologies, Inc. And in that case, the main issue that the court was dealing with was that there was a mandatory arbitration clause in an agreement between Mr. Heller and Uber, and whether that mandatory arbitration clause was enforceable or not. And the court held in its decision that the clause was unenforceable because the clause was unconscionable. This case has significant implications for all of us as consumers because most of our contracts with all kinds of companies, for example, Amazon and Google and telecom companies and gaming companies and whatnot, we, all consumers, whether we know it or not, we have these contractual agreements with these companies whereby if we have a dispute, we are required to submit that dispute to a mandatory arbitration process, and we cannot go to court or we cannot commence a class action lawsuit. That's sort of the general theme of all these contracts. So the court's decision in this case, even though this was in an employment law context, has huge implications on all of those arbitration clauses, especially those arbitration clauses which are contained in standard form contracts that you and I sign as consumers. So we will discuss the implications of this case in today's video. We begin with our usual disclaimer that this lecture is not legal advice. If you have any specific questions regarding your issues, you should contact a lawyer or a paralegal or the Law Society of Ontario for a referral. The arbitration issue has been in our lectures recently. We have posted 3 lectures on this topic. The first lecture was posted on March 23rd, which basically explained what is an arbitration, how do parties resolve their dispute through arbitration. If you don't understand the process, you should check that video out to understand the fundamentals of an arbitration process. The second lecture talked about why these arbitration clauses, mandatory arbitration clauses, are tyrannical, and we explained that in that lecture by giving examples of various contracts that people have with various organizations. And in the third lecture, we covered some of the recent cases that were in the courts with respect to these arbitration clauses. And in that lecture, we also talked about Heller versus Uber. That case, by that time when we issued the lecture, was heard by the Supreme Court of Canada, but the court had not issued its decision. It has now issued the decision, so we are going to discuss that in today's lecture. Just to give you a quick background of what this case was about, Mr. Heller was an Uber driver. He was employed as an independent contractor with Uber, and he had signed a contract with Uber which contained a mandatory arbitration clause. So essentially, if there was a dispute between Mr. Heller and Uber and all the other drivers, because the agreement was in a standard form contract, so if they had a dispute of any kind, they will have to go to Netherlands and submit their case to an arbitrator, but they could not go to Canadian courts to have that matter resolved. That was the fundamental issue in that case. And Mr. Heller and others commenced a class action lawsuit where they claimed that they were not independent contractors, they were employees. And if they were employees, then Uber violated certain rights under the Employment Standards Act. So that was sort of the fundamental dispute. Because there was a mandatory arbitration clause, Uber brought a motion before a judge arguing that the court action should be stayed and Mr. Heller should be required to go to the Netherlands to argue his case before an arbitrator. So that was issue number 1. And secondly, Uber also argued that the court had no jurisdiction. If there was any jurisdiction issue, that needed to be decided by the arbitrator. And so the issue before the court was whether the court have jurisdiction or not, and then if it did have jurisdiction, whether the arbitration agreement, the clause, was it valid or was it illegal? Now, this is how this case progressed to Supreme Court of Canada. At the motions level, the motions judge agreed with Uber and basically said that the court had no jurisdiction because there was an arbitration clause, and so the court ordered to stay the action in the courts. Mr. Heller then appealed to Court of Appeal in Ontario, and then the court overturned motion judge's decision and basically held that the court did have jurisdiction, and Court of Appeal also held that the arbitration clause was unconscionable, and because it was unconscionable, the clause was illegal and unenforceable. Then Uber went on to appeal to Supreme Court of Canada, and Supreme Court of Canada just issued its decision. It is an 8-1 decision, so a panel of 9 judges, 8 decided on one side and 1 judge dissented, although all of the judges agreed that the clause was unenforceable. So 8 judges agreed that the court did have jurisdiction and that the arbitration clause was unconscionable and therefore unenforceable. So there is this concept of the unconscionability in contract law. I'm not going to cover that today. I'll probably do a separate lecture to explain that. But fundamentally, unconscionability may allow a party to get out of the some of the clauses of that contract that they had signed because the clause is unconscionable. The nature of clause is fundamentally inequitable. So there is a 2-part test for the court to decide whether a particular clause or an agreement is unconscionable or not. Number 1, the court considers whether there was an inequality of bargaining power between the 2 parties. So one example could be, or in this case, Uber is one party, which is an international, multinational company, and Mr. Heller is simply a driver who may not have even consulted a lawyer before signing this contract. So there's an inequality of bargaining power between the parties. So that's sort of one thing that the court considers. And secondly, even if there is inequality, whether the transaction, whether the agreement is that improvident, is that unfair. So despite the fact that there's inequality, the agreement may itself be reasonable, and so the court considers whether the agreement itself is improvident, is unfair or not. And if it is, then the clause may be considered unconscionable. So that's sort of the fundamental concept, but we'll talk about it in a separate lecture. Now, the dissenting judge, Justice Brown, he also said that the clause is unenforceable, but he basically said not on the basis of principles of unconscionability, but because the public policy would make this clause unenforceable. Now, it is important to read what the dissenting judge said, because I think that's an important statement. In that, the justice said, contractual stipulations that foreclose access to legally determined dispute resolution, as the arbitration agreement in this case does, are unenforceable not because they are unconscionable, but because they undermine the rule of law by denying access to justice. So that's the heart of the issue. The judge basically is saying that unconscionability or not, when you allow people to have these arbitration agreements, which in essence undermine the rule of law, take away people's abilities to access justice in a meaningful way, then for the public policy reason, we should find these clauses unenforceable. Why I'm highlighting this dissenting opinion is because it is a dissenting opinion, but in my view, it deals with the heart of the problem, which is essentially access to justice. And I believe that in the coming decades or so, this sort of dissenting opinion will gain popularity with the courts, not in the near future, but maybe 30 years, 40 years down the line. What is the implication of this decision? As I said, there are huge implications. Now, all of the adhesion contracts are the standard form contracts that you and I sign. We have no ability to negotiate with Google or Amazon about how they're going to provide services to us contractually. We just simply accept whatever is in their contract. So all of the arbitration clauses in those contracts, if they are unconscionable, or if a party believes that they're unconscionable, then they will lead to significant litigation in the courts about unenforceability of those clauses, and those clauses will be increasingly challenged. So this case has opened the door for challenging such clauses, and I believe that this is going to happen significantly. This is not limited to standard form contracts. The principle will apply to other contracts which were negotiated between parties, but somehow the one party is able to show that the particular arbitration clause is unconscionable. So that will come into play as well in courts. So all of the contracts that people have signed with Amazon, with Google, with Madame, their home developers, with gaming companies, Fortnite, whatever the gaming companies you engage with. So all of those contracts, most of them have those arbitration clauses, and if there are disputes, at least in Canada, people will be challenging those arbitration clauses to have the ability to go to court and have their disputes resolved by court, and in some cases commence class action lawsuits, which are usually unavailable when there is an arbitration clause in an agreement. Thank you for watching.